fine. Who do you want to see? This one? Is that easy?
Yes, that's easy.
Yeah, do that then. Are we ready? Yeah. All right.
Sorry, there's a mismatch between the clock in court and the clock in the rest of the world. Just before you say any more, Mr Nabi, Mr Straker, the court's position, I think, has to be formally neutral. We might be assisted by having someone from your team in court in case matters arise tomorrow which impact on your case, which I think is unlikely but possible. Up to you how you do it, but certainly I don't think the full team need be there. As I say, a way it's often done would be to have junior counsel, or one of junior counsel.
Well, my lord, our discussion at lunchtime led to this conclusion, that either Mr Manning or Miss Kafake will be here in person. The others of us will either be watching or in a position to be told what's happening, and so that whoever it is will be able to deal with any matter which arises, so to speak, ex improviso, and if needs be, a message could be sent to say, in an unlikely event that it was thought my attendance was desirable, that message could be sent.
Well, I'm sure it's very unlikely to be a problem, but as I say, when these cases are set up together, it is usual to have some presence during both. Thank you very much.
Much obliged.
My Lord, one question my Lord asked me before the lunch break was, when was suitability introduced?
Yes, thank you.
Into the 1985 into the scheme, and it was introduced by Section 14 of the Housing and Planning Act 1986. This introduced both the concept of suitability and reasonable to continue to occupy.
So they were introduced at the same time?
They were introduced at the same time. So, my Lord, you have Section 58 2A in the Bundle of Authorities, page 47.
Hang on 1 second. Which page did you say?
Page 47.
Yes.
That's 58 2A. My Lord.
Wait. So that is identical to 1753, isn't it?
Yes. So this was a direct response to Pulhofer.
Yes, right.
And my Lord, you don't have, but we can provide tomorrow morning, Section 69 of the Housing Act 1985, which introduced the suitability concept.
Well, I think that would be useful to have. I can't remember what the practice was as long ago as 1986. Was there any sort of useful explanatory memorandum with the... there will be a formal explanatory note, but the kind of explanatory memorandum we see these days probably didn't exist then.
My Lord, we will check to make sure, and whatever there is, we will provide tomorrow morning.
Well, I think that would be helpful. Thank you very much indeed. Again, just before you get on to the list, one point which I think arises from the submissions you've already made is the terms of the judge's order, which I think we did look at briefly with Mr Straker, and whether we did or not, we have certainly looked at for ourselves. And we just want to see what your position is on the form of the declaration as it was in fact made. we did indeed look at it, Mr Straker, because I've got various notes on it. It's, you don't need to be told, but it's at page 52. And I think the first question is, in the light of the debates that we have had, both with Mr Straker and now with you, do you have any observations about the precise way in which paragraph 1 is framed? Are there ways in which, consistently with your argument, it could be improved? Maybe an unfair question to bounce you with, but I think if you have any observations, it might be useful for us to know what they were.
My Lord, the first point would be that these were the two competing arguments being put before the judge, and so that's why the declaration was framed in the way that it was.
Yes. I suppose what we are thinking about is, if we were to uphold the judge's order, one would want, without deciding points that are not before us, but one would want to give the best guidance to local authorities as to exactly what this means in the kind of situations that they regularly encounter. And indeed, not just to local authorities, but to homeless, and those advising them. Now, to some extent, that may have to be left to the terms of the judgment. But if we say this is the law for everyone, there might be areas where it's capable of being misunderstood or applied in situations where it wasn't intended. I'm not going to ask you to draft on your feet, but I really wanted to raise the point with you so that if before this case finishes,
Yes.
in Mr Straker's reply, for example, you've already got anything you might want to say, we could have the benefit of it. If not, if the question arises, which of course depends what we decide on the substantive point, it may be something that we will want a bit of help from in the interval between circulation judgment and the draft judgment. And not talking about, as it were, allowing the appeal, if we're with you on the point of substance, but about how, whether in the judgment or in a slightly reframed declaration, more guidance could be given to stakeholders, which I don't normally use.
Well, with your permission, I understand the point. It would be helpful if we could have perhaps some time to think that question through.
Well, I think I was ready to think of this in two stages, as you can tell from my rather long-winded way of putting it. I haven't quite thought out what the best way to deal with it is. I think you can simply duck the question now and see whether it arises, but be prepared to have some questions ready, to have some answers ready in the interval between between circulation of the judgment and final handout, or the drafting of the order, making of the order. That's the fallback position. But if before then you have any views, really I think it had to be in the context of this hearing, so
Yes.
to be today, but we'd be useful to have them to feed into our thinking. I don't know if my lords want to add anything to that.
No, I raised this because it didn't seem to me that the two positions covered the entire ground comprehensively. That was all. You've explained that the declaration is, were a historic construct.
Yes.
But we may, as my lord says, need to go a bit further in trying to provide a comprehensive analysis.
It may be that in the end of the day, it's best left to the text of the judgment. There's only so much you can put into a declaration. But let's see how we go. Thank you. Now you can get back to the list.
Yes. My Lord, well, I don't intend to spend very long on the list points. We had a look at Martha Bell's statement in the Al-Shameri case. Now, the appellants accept that if the judge was right as to the nature of their duty, then the list doesn't prevent them from being in breach. That's paragraph 50 of their skeleton, core bundle, page 30. The judge found at paragraph 313, that's core bundle, page 153, that, I should let you turn up the page.
Yep.
At 313, core bundle, page 153.
Yeah.
That even if she was wrong about the nature of the duty, and the council had a reasonable time to find suitable accommodation, the system in place failed lawfully to meet such a duty. And in my submission, this was a finding open to her on the evidence. The judgment analyses the council's evidence at paragraphs 80 to 116, starting at core bundle 80, page 83. And the judge notes the following. Firstly, this point brought out yesterday, that there was no temporary accommodation policy governing the list. That's paragraphs 85 and 87. Secondly, the entries in the PML for Elkundi and Ahmed did not include any statement as to disabilities in their households, paragraph 90. Thirdly, the planned move date did not appear to represent the date an applicant was placed on the PML. That's paragraph 93, core bundle 85, and noted at paragraph 93 that Mr Elkundi was placed on the planned move list on the 10th of January 2020 when he had applied for assistance in 2014.
These sorts of highly detailed points are not subject to the order, are they?
They're not the subject of the order, but they feed into the judge's declaration as to...
Well, do they? I've understood the meaning. I agree the declaration uses the phrase "in particular," but I think that means it's only in these respects. You couldn't have a declaration is unlawful generally, and here are some examples.
No.
So, and the three things are A, which really corresponds to ground one. It's simply a consequence of her being right on ground one. Yes, she is. B, that you can't properly have a list which simply goes by the date you join it, yeah, without distinguishing between people in suitable and unsuitable accommodation. Now that is still in rather general terms, but my understanding is that that is really relating to people whose accommodation is unsuitable because they are disabled. At that rate, that was the example of these cases, on the facts of these cases. And C, the section 149 of the Equality Act, which is of course, not about whether it actually discriminates, but about whether or not proper account has been taken of the need not to discriminate.
Yes, my lord.
But again, the particular form of discrimination the judge had in mind was disability.
Yes.
So this point about being put on the list a lot later than you should have isn't, on my understanding, the basis of the judge's finding.
No. No, my lord, I suppose I can do no better than refer your lordships to paragraphs 307 onwards at core bundle 152. And effectively, what she makes 6 points.
Yes, I'm bound to say, although this is a tour de force, this judgment, I didn't find her fitting her 6 points into the terms of the declaration particularly easy to do. And in anyway, but do you accept that the focus of the declaration is effectively on, at any rate on the facts of these cases, on people with disabilities or disabled people and their families? Yeah.
But there is also the point that the list has people who are in unsuitable accommodation and other people who are in accommodation that is suitable in the mid to short term.
Yes, there were 2 points really. Yeah.
Well, unless I can just so those are my submissions on the plan move list.
Yeah.
Well, moving to functus. This is obiter. And we would submit that the court need not make a decision on this point in this case.
The only problem with that is we may not need to take a decision, but the judge has indicated quite clearly, and people who follow it, that the authority was functus. And another way of looking at it, and we may not decide which is right, is that under 193, it's one thing to say there's a decision on conditions, and once that's reached, that's it. But section 193 is a duty which begins on a particular date when they're satisfied with certain matters, and ends on a particular date when one of the things occurs, and it will extend over a period of months and years.
Yes.
So they're not functus in the sense that they're constantly having to provide section 206 suitable accommodation or secure 206 accommodation. So they are functus by definition. They're discharging the duty, and it's not a one-off duty. It could cease to be suitable. It could become suitable. So the contrary argument to the indications of Mrs. Justice Steyn is that where you're dealing with a duty, not a decision on eligibility, and the duty continues over time, and you're dealing with discharge, you may adjust the method of discharge to reflect the current circumstances. And it's not really a question of functus at all.
Well, my submission on that would be this. Firstly, that there has been and it's really paragraph 282 of the judgment, which is at core bundle 146. And her points starting about 5 lines down. First, the continuing obligation is to ensure the accommodation secured is suitable. If it's unsuitable, then you secure suitable alternative accommodation. But there's no continuing obligation to assess whether accommodation, which the local authority has decided is unsuitable, remains so. Secondly, there's an interest in finality, to which Lord Justice Peter Jackson referred to in Zamberton. That was applicable when applicants has received a favourable statutory review decision that their accommodation is unsuitable. And the authority is not trapped, my lord, because there's a simple answer for the authority, which is simply to, if it decides that because of change in circumstances, when the authority decides that the accommodation is unsuitable, our case, it's in breach of duty. It can only perform the duty by making an offer of suitable accommodation. At that point, if some extraneous circumstance means that the accommodation can be deemed to be suitable, what it needs to do in our submission is just to make an offer of that accommodation. The reason that is important is because it preserves the integrity of the scheme, and that it makes an offer taking into account the matters set out in section 193. The offer letter will say you have a right to request a review of the suitability of this offer, and it keeps everything clear and certain.
But why can't they send a decision saying, we told you previously that this was unsuitable, circumstances have now changed, we consider that for the moment it's suitable. You'd still have a right of review of that decision, wouldn't you?
My lord, as long as that letter made clear that effectively we are offering you this property now on the basis that it is suitable, despite what we decided earlier,
No,
that would be sufficient.
Say you're in a particular property for a short period, and they've said to you it's suitable for the next 3 months, as far as we can see. And then towards the end of the 3 months, they write and say, actually, it's going to be suitable for a further 2 months. There isn't anywhere else. There's been a sudden rush of even more demanding cases, and it's suitable for you to remain there for 2 months. They wouldn't be offering you anything. You'd be staying where you were. But if they did it that way, you'd be able to review the decision, wouldn't you? So they'll have decided an issue. Either way, we're now proposing to discharge the duty is sufficient because it's suitable, and you'll be able to review and appeal that, wouldn't you?
Well, I agree. The key point is that the right of review in any decision is clearly notified. And my lord, what we on our side are anxious to avoid is a level of informality creeping in, especially when you're dealing with people who may not understand the complexity of the procedure, and they don't realise that this new decision attracts its own right of review. And so our submission is the simplest way of doing that.
It's not a question of simple, it's a question of whether there's a right of review under 202. If there's no right of review, then you're right. It's not an argument of law to say it'd be easier all round. And it may not be listed under 202, the decision on suitability as to the discharge of the duty, and if it's not...
So 2021F, core bundle, authorities bundle, page 113, says any decision of a local housing authority as to the suitability of content offered to him.
Where are you?
On page 113,
Yeah,
2021F, it's the last.
Right, okay. Any decision as to the suitability. So it's got to be offered to him, otherwise there's no appeal and no review.
Because
But does offer to him there mean another offer, or does it simply mean that which is secured to him?
well, in my submission,
It's where there's a formal offer.
yeah,
Okay, so they couldn't review a decision, a change of decision on suitability,
no,
which wasn't accompanied by a formal offer of a property.
but that complied with the requirements of 193 as to how such an offer is to be made.
I'm maybe in agreement with your submission. At the moment, not clear why, in the light of paragraph 281 of the judgment, this question arises at all in this case.
No, my lord, it doesn't arise.
It
arises.
It doesn't seem to be
Go on.
ambiguous at all. The judge found that there was no attempt to make further decisions.
No.
This issue is about the making of further decisions.
Yes.
And so, interesting though it may be, is to decide what the nature of a later decision in a 193 case might be. It doesn't seem to me at the moment that it arises for our decision because there wasn't a subsequent decision on the judge's finding.
As I understand it, really that's common ground, but Lord Justice Popplewell, when giving permission, doesn't mind the view we take, but took the view that the point had clearly been fully argued. Mrs Justice Steyn had said something on the record in the judgment lots of people are going to read. And there might be something to be said for us dealing with the point, albeit obiter. He doesn't say, but I'm sure he understood, on the whole we don't like doing that, but sometimes it's appropriate. Isn't there a risk that if we don't deal with it, what Mrs Justice Steyn says will stand and will be followed, as it were considered obiter? And if she was wrong, it's a pity that we don't take the opportunity to say so. You think she wasn't, but...
Well, my lord, of course I understand the logic of that. The only counter argument would be, in another case where the point arose again, of course what your lordship said in this decision would be highly persuasive, but it would not be binding. It would be obiter.
No, of course, but
I
that's
can't
the way of the world.
But then an authority at the moment, they're not going to take the risk of taking a decision, even if they think there's a good change of circumstances. Whereas if we say that may not be correct, or certainly if we say, obiter dicta, it isn't correct, then a brave authority may say, right, it's safe to go. Otherwise you never have a decision on it, because they'll all be too afraid to try.
Well, my lord,
I certainly think I take my lord's point. You certainly shouldn't assume that we won't decide the point, and therefore we ought to have your submissions on it, which have we largely had.
I think you have.
Well, going back to Mr Straker said about this, it was effectively that the other decision, Samberton, was to do with a threshold decision, of which the analogue in this case is the acceptance of the main housing duty. And that once you've accepted the main housing duty, you can't then unaccept it.
Well, if I may,
In the absence of the odd extreme cases.
so I understand that as Mrs. Strake is saying, well, there's actually a qualitative difference between an eligibility decision and an unsuitability decision, and Samberton is limited to those decisions that fall on the eligibility side. Well, if I might,
We haven't yet been taken to Samberton. My lord obviously knows it backwards.
yes, it's at tab 56, which is at page 884. That's the third bundle of authorities. Yeah.
Yes.
Yeah, 50 plus is third bundle. And if I may, it's always slightly embarrassing making submissions on a judgment where my lord has given the judgment.
Sure, you can get over the embarrassment.
But, my lord, I would say these are paragraph 3, page 886. Is sort of the general statement of principle. And then paragraph 29 is the conclusion on the decision making, and it's subparagraph 1 of paragraph 29, the final sentence, or the penultimate sentence. The Act does not allow for the withdrawal or review of a favourable decision, only an unfavourable one via review and appeal in the sections 202 and 204.
Remind me, what was the decision? It was the decision that the case fell within section 1931, is that right?
Well, in Sambotin or in our case?
In Sambotin.
In Sambotin, the question was whether someone was eligible or not.
That is section 1931.
Yes, it was whether the main housing duty was owed or not.
They said they were eligible, but they said it's another local authority. They sent it off, and the other authority said, oh, no, it's not.
Yeah.
And then this authority said, oh, we've had second thoughts. You're not eligible after all.
That's right.
That's what happened.
Yes.
But why should you seem to accept that they could move in your direction. That's not what 29.1 says, because that's got the review and so on. But if they decided, if the authority decided that this was suitable, and then they decided a few weeks later, in fact, it's not suitable, you've had another baby, or sadly the children have become ill or something, you accept that you can switch to performing your duty in a different way, and you can move from viewing the property as suitable to viewing it as unsuitable. And that, you say, is all right. That means they must have functus or power to do that.
Well, I would respectfully submit that Ms. Justice Steyn got this right. She said, although there's a duty to keep under review, a continuing duty to keep under review, that accommodation remains suitable, there's no such duty where accommodation has been determined to be unsuitable.
But what's the difference?
Well, the difference is that where an authority has determined that accommodation is suitable, the applicant can request a review, firstly, which they wouldn't be able to do with the other decision because it's a favourable decision to them. Secondly, and if they're successful on that, then the point being determined in their favour. If there's a change in circumstance that means that the accommodation is now unsuitable, they would put that to the authority and ask the authority to make a fresh decision on the issue of suitability because of the authority's continuing duty to ensure that accommodation remains suitable.
Where's the continuing duty come from?
It comes from section 193 read with section 206, that the duty is, for as long as it continues, the duty is to provide suitable accommodation.
So if they think it's not unsuitable, I mean, that doesn't explain why you can't change your mind. What that says is you're not functus going one direction, the favourable direction,
Yes.
because you've got a duty which continues.
Yes.
The same logic applies to a shift the other way, and the only question is whether or not within the scheme you shouldn't have that, because offering accommodation means a formal offer of accommodation, not leaving you in accommodation that's suitable. I think that's what it really comes down
That's what it really boils down, because you can't, you're precluded from requesting a review until there is something that amounts to an offer. Now, as long as it complies, what is done complies with an offer and the letter which says this, and this is, I stress is key, which says, we're now offering it to you again because we now think it's suitable, and you can request a review of this. That would protect the position.
If one looks at 282 of the judgment, second sentence begins, in my judgment. Could we have your submission on the proposition that that goes further than the case of Sambotin does in its terms? That it appears to be suggesting that this principle applies to any decision which happens to favour an
My
applicant.
Lord, I would support that. I would say that is correct. And I would rely and refer you all
At the moment, I was only anxious to frame the matter to understand whether you accept that it goes further than
Oh, I see.
the decision in the case. When I
My Lord, I don't accept it goes further. I
I'm
think-
sorry, I thought you just said you did accept. I'm sorry, no, I'm not being difficult. I just want to make.
No, absolutely.
I misunderstood. Okay,
No,
I don't accept.
No, it's my fault. My Lord, I don't accept that Mrs Justice Steyn, in making that, in that sentence, goes further than.
Right, you say that that she accurately summarises the effect of the Sandbroton decision.
Yes. And my Lord, I was going to refer you to an authority, B and the London Borough of Redbridge, which is at tab 57, which is the final, the third bundle of authorities. Which is a suitability, it's a suitability case.
The tab
Tab 57.
57.
Page, it starts at page 896. My lords, I wonder if I could ask you to read pages 896 and 897, and then I shall take you to some passages in the judgment.
Yeah. Sorry. Lord's in the same position.
Thank you.
Yeah.
Yes. So, my lord, if I may ask you then to turn to paragraph 32, which is page 905. So the point here was, well, look, there's a continuing duty to provide suitable accommodation. Does that mean you can request a review at any point because the duty continues? And the authority said, no, you can't do that. You've got 21 days.
It's one decision, one review.
Yes.
Right. It's not one decision with a continuing duty you can keep on reviewing whenever
Yes.
you choose. That's what this tells us.
It tells us. So what it also says is that paragraph 34, Mr Johnson, who appeared for the homeless applicant, he said that there's a qualitative difference between decisions as to eligibility and priority and homelessness within the meaning of section 193, and on the other hand, decisions as to suitability, affordability. The former are broadly criteria that are fixed and capable of final and binding resolution. the latter is inherently fluid. Suitability, affordability of accommodation may change over time. It cannot be in the intention of Parliament to shut out the possibility of seeking a review when the suitability, affordability of accommodation changed after a period of time. And we see the deputy judge saying it wasn't open to the court to read a caveat into section 2023 so that it doesn't apply to 2021F. Just because there's a continuing duty doesn't mean that you can request a review at any time. That essentially is my point here, is that having reached a decision that accommodation is unsuitable, that is not a decision that any applicant would ever seek a review of, because that is presumably is what they would have argued and had received a decision that it's unsuitable. If that's then going to be replaced with a decision that actually, because of change in circumstance, the accommodation is suitable to fall within 2021F, has to be offered in whatever means complies with section 193, and then a review can be requested. And it is not very onerous on the authority at all, for the authority to do that.
Hold on. So it must be replaced with a decision which meets the requirements, it constitutes an offer, whatever that means in that
Yes.
section.
So that you then fall within 2021F.
I think what you're saying really is two things. From the statutory scheme, unless it fell within 2021F, it's unlikely that the statutory scheme permitted it as part of the continuing duty. Since they've set up an elaborate scheme of reviews, if it doesn't cover reviews, the implication is that there's no power to review unconnected with the review. That's your first submission. And then your second one really is that it doesn't fall within 2021F unless there's something that amounts to an offer to him. But one wonders, it may just be clumsy, any decision of a local authority as to the suitability of accommodation offered to him in discharge of their duty.
Yes.
If it had said secured to him in discharge of their duty, there'd be no problem, would there?
Well, there may be no problem at that stage, and I'd have to think about that. But there may be problems. Well, it has to comply. Let's say it's offered under section 193. If we go back to that, 193, and I'm looking at page 97 of the authorities bundle, sets out the formal requirements for an offer. Because, and I say that because a refusal of that sort of offer can release the authority from its duty. So, for example, just by way of example, 193 subsection 5 at page 97. Or 193 subsection 6 C. One nine three seven. And also 1937 AA.
Sorry, what's the point you're making? I've got lost.
The point I'm making is that what is an offer under Part 7 has meaning in the context of Section 193, because the refusal of an offer can cause the duty to cease where the offer complies with the requirements set out in section 193.
But I'm obviously haven't got the bigger picture here. I thought this all fitted into an argument that local authorities weren't stuck and unable to take the position that property which was initially unsuitable has now been decided to be suitable, because as long as they go through the correct hoops to make a reviewable offer, they can simply say, we now offer this to you as suitable accommodation.
Yes.
But are you saying they can't do that?
No, well, that's my case.
Your case is that's the only way in which
That's the only way they can
Yes,
do it.
quite. But well, I must have misunderstood. At some point I thought you were saying there was a difficulty about that because the offer had to be in a very particular form.
So I didn't express myself very well, perhaps not for the first time today. My point was, it's a difficulty for the authority if they don't do it in that way.
Oh, I see.
Because it means they can't then rely on a refusal of any such offer to say, well, look, our duty
No,
is
I
citizens.
get all that. But the important point is that in a case of a kind we're looking at, all they have to do is to say, well, we have reconsidered the position
Yes.
in the light of the changed circumstances. We now believe that this property is suitable in the discharge of our duty under section 193. We hereby offer it to you, square brackets, and it makes no difference, you're already in it.
Yeah.
You wouldn't take any point on that.
Yes.
And any other bells and whistles about the form of words they have to use.
Well, the
are
key
attached.
point would be, and if you refuse it,
Yeah.
our duty to you will come to an
Yes,
end.
okay, so that wording is put in.
Yeah.
And you say, you're saying they can do that?
Yes, I do.
Yes.
I mean, to be fair to you, you're responding to me. I was saying, oh, well, treat the word offer as secure. And you said, no, you can't do that because offer, it means a very specific thing in this context. And you're really showing me other areas, what has to be in an offer,
Yeah.
what the consequences of that. So you're really telling me I've got it wrong very politely. If you hadn't been polite and just told me I got the wrong end of the stick, we'd have got you.
Right, well, I see how you put it.
Yeah.
Thank you. My lord, then the final point is waiver. And there's really very little I can add to this. My lord, you've seen the section 184 notification. That's a letter which said you have agreed to remain homeless at home. And I think it's not contended that any agreement was only at a point when interim 188 accommodation was being canvassed. And there was no agreement post acceptance of the main housing duty. And so the learned judge was right to find that Mr Al-Shameri had not waived his right.
So, agreement recorded in the course of an offer accepting the main housing duty is, by definition, prior to the acceptance of the duty. That's your point. I suppose there might be some argument as to whether that was a continuing state of affairs that continued afterwards, but that's not how the argument ran.
Well, what we have is the Gail Fenton witness statement, and we have Mrs Justice Steyn observing, in my submission quite fairly, the letter was quite, a lot of letter is in pro forma terms, and you've got one paragraph buried in the middle of the third page, and actually if one reads it all, it's expressed in terms that even housing lawyers, she said, might find it quite difficult to understand.
If we abandon the language of waive as we did yesterday, what we're talking about is whether or not the authorities discharge the duty for the moment, or is discharging the duty, because the person has agreed that the duty will be met in effect by him staying where he is rather than going. And if he's not been given the opportunity of knowing that it's got to the stage where they're under a permanent duty, he can't, almost by definition, be accepting the duty will not be discharged by other accommodation and will continue to be discharged by him staying where he is. He can't by the laws of physics, have been agreeing to the duty being discharged in that way because it hadn't arisen at the time he said it.
Yes. My lords, unless I can assist any further.
No, that's very good. Thank you very much indeed. Yes,
my lord.
straight.
Can I, in reply, deal first with the functus question, which has just been discussed?
Yes.
And as far as that is concerned, the position to have in mind in my respectful submission is this, that if you go back to the right to request review of decision because something is made of the proposition that in the circumstance of a council saying 3 people have moved out, this is now suitable, that one couldn't say, please may I have a review. The right to review, which has been referred to in section 202F, 1F I should say, is any decision of a local housing authority as to the suitability of accommodation offered to him in discharge of their duty. So it's any decision which bears upon the question of suitability, which occurs in the course of the discharge of their duty. And this would be, in my respectful submission, quite clearly such a decision. And
Why do you say quite clearly?
because if one proceeds upon the footing that the duty as given by the legislation is a duty which continues until certain given events occur, then we have a position whereby what is the decision taken which relates to something, answer it relates to suitability, what is that done within? It's done within the discharge of their...
Well, I don't want to know within the discharge. It doesn't mean sort of in the general subject matter of section 193. The decision must be taken to discharge the duty, i.e. to offer someone suitable accommodation.
Well, my lord...
That's what in the discharge of means, surely.
well, no, it's not in the discharge, it's in discharge.
Well,
of their duty. And
thank you for correcting me, but even if it was in discharge, wouldn't the same not apply?
well, my lord, I would respectfully not agree with what your lordship is putting to me there, and it appears, if I may respectfully say so, that the deputy judge, in the case to which reference has been made, the Redbridge case, took the same position, because if your lordships go back to this, which is volume 3 of the authorities bundle, at page 906,
Is this Mr Justice Johnson, as he now is?
yes. And it's page 906, paragraph 37, against letter C. Defendant was under a continuing obligation, section 1932, read with 206, subsection 3 and 206. That doesn't mean that the defendant made a continuing decision that the accommodation was suitable. It made its decision on suitability of suitability.
So sorry, I haven't got there yet.
It's paragraph 37, page
Paragraph
906.
37, I'm there now, yes, thank you.
Continuing obligation to secure, first sentence, doesn't mean made a continuing decision that the accommodation was suitable. It made its decision on suitability on 11 December. Thereafter, it could have been asked to make a further decision as to suitability if, for example, circumstances changed. And of course, the argument put forward by my learned friend is this is a one-way exercise. I say not so. And then if one reads on, if it agreed to make a further decision as to suitability, then that decision might be subject to a review request under section 2021F. And I pose for your lordships the point that someone asks for a further decision as to suitability contemplated in paragraph 37. What if the neighbours point out of a sense of civic obligation rather than spite, look here, those three students have now moved out permanently because they've got jobs in London. And in that circumstance, in my respectful submission, it's patent that one can undertake the task of saying, I'm going to make a decision as to suitability, which will get one within F, and proceed as follows. My Lord, so I leave that question there of functus, if I may, and return to what are plainly the important matters, important and complicated matters that your Lordship have got to consider. And a number of matters were, in the exchanges which occurred in the course of my learned friend's address, were crystallised, and it's possible to draw attention at this stage to those particular matters and to take it in two stages. First, simply to have in mind the terms of the legislation, and second, to have in mind the sequence of cases which led to the Ali case which your Lordships have looked at. First of all, there was a very profound observation this morning which is in immense importance, namely that you can be homeless in accommodation. My Lord Justice Lewis discussed this with my learned friend. It's agreed that such is the position, and it's agreed that, of course, there is a multitude of varying circumstances. Homeless in accommodation. Second, and this emerged in particular from the exchange between my learned friend and my Lord Justice Peter Jackson, who went to the point of function, considering the functions in the legislation. Function first is a determination as to your status. Are you a homeless person within the terms of the legislation, where reasonableness to occupy is a critical question. Now, that is not, of course, logically determinative of any question which might arise under any subsequent consideration as to how you might, in the exercise of a duty to secure accommodation, view that accommodation for a period of time. I'm talking about allowing someone to stay there. And it is to be observed, of course, that it is functionally to be distinguished from suitability, with suitability of being capable, as we saw yesterday, of varying from person to person in consequence of the ability to make, by the Secretary of State, certain orders as to what he may specify as amounting to or not amounting to suitability. And your Lordships, I think, were provided with the one that I mentioned with this morning on your Lordship's table, first thing.
Sorry, I have no idea what you mean.
Oh, I beg your pardon. Your Lordship will recollect that yesterday I referred your Lordships to section 210 of the Act.
Not at the moment, but it'll come back to me.
And section 210 enables the Secretary of State by order to specify circumstances in which accommodation is or is not to be regarded suitable for a person.
Okay, I'm with you now. Yes,
I was just making, so to speak, the administrative observation that left on your Lordship's table this morning was the order that was referred to yesterday.
I haven't looked at that, but what's the point in it that we need to look at? Or is it just to prove?
The point in it is that it's a matter of its existence and the ability of the Secretary of State so by order to specify, because of course the question of suitability capable of being directed by the Secretary of State in that way is, I suggest, indicative of the fact that it is not intended, the question of suitability, to operate as a kind of substitute for consideration of the exercise of the duty under 1932. And that leads directly to the point about which there was also some discussion about the elasticity of the term suitability, functionally to be distinguished from reasonable to continue to occupy, and whether or not the temporal considerations bear upon that matter of suitability. Now, I readily accept that as being so, but one wants to be cautious, with the greatest respect, of extending or suggesting that suitability can be used as a kind of tool whereby one can see, well, one's duty is being performed by assigning the label of suitable to something which is accommodation, but wouldn't ordinarily bear that label suitable unless one was seeking to see it in a different light. And that leads to this matter, my lords, which I say is the critical issue which arises in this case. And it's this: it's whether the duty in respect of the homeless person in accommodation, whether or not that accommodation bears the label suitable, must generate, if it does not, an immediate offer of suitable accommodation, or whether it is still, as I would say, part of the exercise in the reasonableness to be attached to 1932, both as to time and, if necessary, as to other matters. And my lords, I respectfully say, in the light of the discussions which have emerged in connection with the Ali case, that it's perfectly apparent that there was a sequence in that trilogy of cases which went to the House of Lords, whereby ultimately it was recognised by the House of Lords that a period of time, reasonable period of time, for the execution of the duty must be allowable. And I will come to show your lordship some parts of that trilogy. But if your lordships just bear this question in mind, if in the Ali case Lady Hale was conscious of the fact that there were some of those before the House of Lords in respect of whom the accommodation was not categorised as suitable, then she must have been allowing for a period of time for the fulfilment of the duty, for that is what she says. And as a matter of fact, there were persons in that case before the House of Lords whose position was just as I've described it. Now, my lords...
Mr Speaker, when we're talking about time to perform the duty, we're really talking, aren't we, about time beyond what's been described as administrative steps. I mean, because in any case where a judge grants a mandatory injunction, they grant time, usually a number of weeks, which is time intended just to allow the administrative steps to be carried out. And so really when we're talking about reasonable time, we're talking about something different, aren't we? This is just forgetting our terms.
Yes, my lord, it is a matter of getting that right, because I readily accept that if one simply identified administrative terms, that it takes the Birmingham City Council X minutes to produce the documents for a property, etc.
Yeah.
And so those administrative matters can be put like that. But what I am saying bears upon the question and constitutes a reasonable time is the circumstances that obtain in Birmingham.
And understand that. So, in other words, the starting gun isn't being fired immediately. because of the overall circumstances.
Absolutely right, my lord. Absolutely right. And section 206, as your lordship saw yesterday, and I think in the course of the argument today as well, section 206 indicates how these are to be performed, and they're all to be performed. And one curious question, which hasn't really been the subject of much debate, is the circumstance of someone who is occupying accommodation which is, so to speak, nothing to do with the council, in the sense it's not ours in any shape or form. It may be that it's owned by the friend that my Lord Justice Lewis refers to. And then when one looks at section 206 and sees, well, how can that be secured by the council, one realises, I suggest, that one is embracing actually the language of suitability in a way which not really intended.
Leaving aside the time needed for getting the documents ready, getting the keys back and cleaning the house, if somebody had at 10 o'clock on Monday morning the letter saying the duty is owed at you, and they turned up at the office at 12 o'clock and said, we've been staying with our friends, they've kicked us out, we have nowhere, stress, nowhere to go to. Doesn't the acceptance of the duty mean you've got to do something, even if it's a travel lodge, for a couple of nights in those cases, until the administrative duties are concerned? True it is, you can't expect the end property to be available immediately the letter drops on the door. And it may be that where they are, or where they are with their friends, will be perfectly suitable. And that may mean that the duty is not being breached. But if there isn't any accommodation, and if the long-term planned accommodation isn't yet ready, you will be in breach if you leave them on the street.
Well, my lord, yesterday I was at pains to state that in the case of the sort of person that your lordship is identifying, so to speak, visibly, without means, home, anything, then the position would be, and is one in Birmingham, where accommodation is there
But
and
you're
then.
under a duty under section
There and
1932
it
to provide
arises because of the duty. And on analysis, it arises because of the duty, because the duty on our case is you perform this reasonable period of time. I ask myself, I ask the court to ask itself, what is a reasonable time in the circumstance that your lordship has just outlined? And the answer which comes back resoundingly is a reasonable time is by the end of this evening, please.
Yeah.
And it's an execution of the duty, but it's nothing which undermines the argument which I'm presenting, because it exposes quite an interesting situation which arises in terms of would you rather stay where you are at the moment whilst we fulfil our duty, or would you rather go into some temporary accommodation in performance of our duty? And if that on offer happens to be a bed and breakfast or whatever it may be, viewed as highly undesirable by the person you're offering it to, if that's then refused, the position is one whereby the City Council can wash its hands under 193 of that particular applicant. And so that's a highly undesirable circumstance potentially, because there an offer has been made of accommodation which has to be regarded as suitable in the example being given, but it's a very, or potentially, an undesirable situation to arise. Now, just to go back, if I may, to the point I made about how Baroness Hale was undoubtedly dealing with those who were not in suitable accommodation. Can I, in order to deal with this, take your lordships back to, it's in volume 2, of the 3 authorities as they're put, and to see how the issues emerged and changed somewhat as time went on. Mr. Justice Collins is at page 488 of the second volume at flag 37, and your lordships will see that at paragraph 20, foot of the page of 500, he sets out the circumstances of the individual claims, and in doing so he inserted certain commentary that he made. So if you go to 503.8, your lordships will see that he records what the council accept, being recognised, third line against number Roman 8 on page 503, recognised that it's not reasonable to expect him to continue to occupy his present accommodation. If so, it's impossible, in my view, to regard that accommodation as suitable. So Mr Justice Collins was merging the two matters, reasonable to expect him to continue to occupy, and the question of suitability. And curiously, when he came on to deal with how suitable accommodation could come to be provided, at paragraph 26, page 511, he said, last sentence in paragraph 26, that it had to be provided directly, or, as I have said, within a reasonably short time. So in that case, at that level, that was how that matter was being treated. When one gets to the Court of Appeal, at page 526, against paragraph 34, reference F, we have the submission which Mr Luber, who had come into the case at that stage, was making to Lord Justice Ward and his brethren in the court. And he submitted that the word had to be construed accommodation the same way.
No brethren, his sisters.
Well, yes, I'm conscious of that, my lord. I was conscious after I said that. I apologise if that's the inappropriate term today. His main submission, paragraph 34, last sentence, as I understood it, was that unless the accommodation is reasonable to occupy, it is not to be treated as accommodation for any purpose at all, and no question of its suitability and its temporal adjunct arises. And so that's how the character of the argument was there being pursued. Lady Hale...
Well, if I may, Mr Straker, this is all what we established this morning, wasn't it? That the case changed in the House of Lords.
Yes, and what I'm getting to here, my lord, is the point which is directly within the terms of the response that I desire to make, that Lady Hale was dealing with a situation whereby one had those who were in accommodation which wasn't regarded as suitable for their continued occupation. And your lordship will see, because she says what the position is at paragraph 27.547, and then at 38.549, in the Birmingham case, this interpretation has the advantage that the council can accept that a family is homeless, even though they can actually get by where they are for a little while longer. The council can begin the hunt for more suitable accommodation for them. And then we have 42, which your lordships have seen, which I don't read out. But if one goes on to...
Sorry, it would help me to keep my attention. You've taken us through a whole lot of... I haven't understood what point you're trying to make. If you tell us what the proposition is, then it'll be clearer whether or not these passages support it.
Yes, my lord. I mean, the principal proposition that I wanted to advance in reply in connection with these cases is that they were dealing with and concerned with not merely those who were in accommodation which was regarded as suitable, but also with those who were in accommodation not regarded as suitable or regarded as unsuitable. And that therefore...
Dealing with people in accommodation which was regarded as unsuitable.
Yes.
And what is the other category?
And regarded as suitable in terms of, and this is accommodation...
Regarded by whom?
Or either the City Council or by the City Council. I mean, maybe there's a better word.
Short. Don't understand. Well, surely, in one sense, that's obviously the case, or there wouldn't have been a dispute. I'm lost. Keep going.
No, well, my
Perhaps
Lord,
it'll become
it's
clearer.
very important, if I may, if I could just step back for a moment, because this is a matter of where your Lordship should not be lost. It's important because a case has been developed to the effect that the duty is immediate and that it requires immediate action, subject to any point about the pieces of paper which have to be filled in. It requires immediate action, and that the position is one whereby suitable accommodation, whilst the duty is being performed, has to be provided, because that's the way in which the duty is formulated. So it is said. And what I'm saying is, no, that is not so. The position is one whereby Section 1932 simply means what it says. That Section 1932 has to cover the entire range of circumstances, hence the discussion that's prompted by my Lord Justice Lewis. And then we get to the circumstance of seeing that in this case, the position was one whereby there were those who were in accommodation, not regarded as suitable or not classified as suitable, who were just staying there, and it wasn't regarded as a breach of the duty to allow that situation to continue, whilst the local housing authority performed its duty under 1932 by seeking to deploy their inadequate assets in a way which dealt with the multitude of problems represented, in this case, by the list which has been subject to some criticism.
The difficulty with that formulation, as it seems to me, is that it simply doesn't fit with what Sale is saying in paragraph 42. That at the bottom, the second half of paragraph 42, and this has become increasingly clear to me as we've been thinking about this, shows that pretty much what she seems to be thinking about is what we've loosely called administrative time. That reading it from accordingly, there will be cases, which are the sort of cases that we're talking about here. Occupying accommodation is not reasonable on a relatively long-term basis. Wouldn't be unreasonable to occupy for a short time, while the authority investigate his application and rights, and even thereafter, while they look for accommodation to satisfy their duty. Now, I mention that because it seems that is absolutely not the same as the submission you just made a moment ago, which is while the local authority sort out where this person stands within their great scheme of things. And I'm, in saying all of that, I'm acutely conscious of the difficulty that your authority and others face in having to do that. But Baroness Hale is clearly, to my mind, pointing there to there being a short period of time, her words, in order for the local authority to do those things.
Well, my lord,
Not for,
I'm
not for
sorry
people
if
to
I
take
gave,
the- not for people to
the
take-
impression if that was...
No, I'm not suggesting that you were misquoting that. I'm just saying that your submission to us a moment ago, which is that we're entitled to time to sort out where this person fits within our many, many responsibilities, is not what is being said.
Well, my lord, that last bit, in terms of we have time, please, to work out where this person fits in our responsibilities, is certainly not what I'd intended to say, and I apologise if that's what I said. And what I intended to say, and do say, is that a reasonable time is, in accordance with proper interpretation, to be allowed, which enables the City Council to do precisely what Lady Hale is there talking about, while they look for accommodation to satisfy their continuing Section 193 duty.
You've got
Yes,
to
but the
look
word
at
is
opening
continuing.
words.
Yes?
Sorry, I beg your pardon. Yes.
You go first.
I mean, 42 says, given that the authority can satisfy their full housing duty under Section 193 by providing temporary accommodation, which must, of course, be followed by the
Yes.
provision of further accommodation. And that's why, as my lord says, it says continuing accommodation. Lady Hale is assuming that something in the form of accommodation is being provided for a short term, let's avoid the word temporary, for a short term basis. She's not saying there's going to be no accommodation, and the question is whether it's implicit that that has to be suitable accommodation, and what is suitable is influenced by the fact it's short term, or whether it doesn't have to provide any accommodation whilst they take a reasonable period of time to decide what accommodation.
Well, my lord, I would respectfully say and suggest that it's apparent that that is referring to the circumstance which can arise after the investigation of the application rights, i.e. we've investigated your application and your rights, and we label you homeless intentionally in priority need and so forth. And now what is being said is you are a person who is homeless at home, even thereafter while they look for accommodation to satisfy their continuing Section
Yes, but
193
that's
duty.
ducking my lord's point. My lord's point is that during that intervening period, while they're looking for something, the homeless at home accommodation has also got to be suitable. But in deciding whether it's suitable, you can take into account that it's only in the short term.
Yes, but
And that's the whole point in the whole case. This is the construction that is being put to you is one which is frankly in the local authority's favour, except in this case because of the letters they wrote. If they'd written a different kind of letter, this is the construction being put to you is bad for the outcome of this case, but it's not bad for the authority generally.
yes, but that not bad for the local authorities generally depends upon ascribing the label of suitable to the accommodation which is the accommodation at which the individual
Yes.
is homeless at home.
It does, you're
Depends
quite right, but
completely
that-
upon that.
It does entirely, but that's nothing wrong with that, is there?
Well, if one looks at 193, one wouldn't get a hint about that for a start.
Well, one would. Well, I don't. I think one would actually, but the fact is that Lady Hale has told us what it means, so we don't need to do an untutored exercise.
Well, my lord, that's the position, but Lady Hale told us in respect of both, I say, the circumstance of the homeless at home whose home happens to be given the label unsuitable, and the homeless at home whose label is given of suitability because that's a convenient thing to do, it may be thought. But if your lordships look at paragraph 49, the learned Baroness said that it may be that in some or conceivably all of the Birmingham cases, a critical examination of the facts would establish that the council were at some point in breach of their duty under Part 7. Thus, the time taken to find Mr Ali may well be beyond what is defensible. While the council were entitled in principle to leave the families in their current accommodation, for a period, notwithstanding that it was accepted that the accommodation would not be reasonable for them and their families to continue to occupy, must be a question which turns on the particular facts, whether in any particular case the period was simply too long. However, the basis upon which the applicants in the Birmingham case argued, and so forth, I don't read on. If your lordships go back to paragraph 24, your lordships will see, because Baroness Hale tells us, that in 2 of the cases they had been provided with accommodation, but it was later accepted this was not suitable for them. And then it goes on as to what transpired. So
Hang on, they were moved out of those, they were.
yes, but so that when one gets to paragraph 49,
Well, wait, sorry, but isn't that quite important? Why is it helpful to see that they were in accommodation that was not suitable?
because, my lord,
They weren't in that accommodation at the time that Lady Hale was considering.
no, because the position was one whereby they eventually moved, but the circumstances had been that in 2 cases, whilst this litigation was proceeding, and of course the Court of Appeal had made certain relief in connection with that, but Lady Hale, who agreed with the others that the Court of Appeal had got it wrong, was alive to their status in the course of the case, and went out of her way to say that you'd have to have a detailed critical examination of the facts in the Birmingham cases to discover that. And of course the relief which the Court of Appeal had granted was set aside.
Is your point simply that in the case of Ms Abdullah and Mr Ali, as we can see from para 24, at part of the time covered by the claim, they were in unsuitable accommodation?
Yes.
Right.
Yeah,
It's
absolutely.
taken a long time to get there.
But do we know that, though? Because there were issues about it. They were in accommodation, first of all. Something had been provided. And then there would be a question as to whether that was suitable at that stage, for a short term, or whether it was suitable for the long term. And I'm not sure that we've got enough facts.
Well, my lord,
To know.
precisely when, how, and in what circumstances each one of these individuals in the Ali case before the House of Lords and the accommodation status of each is not something which I can respond to, Your Lordship, meaningfully.
Because we don't know
about.
But that's my lord's very
I
point.
appreciate that, my lord, but the point is not so much, if I may respectfully say so, whether I can answer Your Lordship's question, but rather whether Baroness Hale had in her mind the fact that she was dealing with at least some applicants who were, in the currency of the cases, in unsuitable accommodation, and whether or no the City Council had a reasonable period of time in connection with that. To which the answer can only be, in my respectful submission, see those paragraphs 24 and 49, yes, that was so. And if that's right, a great deal of trouble and anxiety as far as this case is concerned falls away, because it then becomes perfectly clear that what Lord Scott and Lord Hope were saying was simply this, that this is the position that we take vis-a-vis Lord Justice Auld versus Lady Justice Arden. This is the position we take, and, if I may be permitted the expression, sotto voce, perhaps Lady Hale didn't say it loudly enough in her speech. So that's, in my respectful submission, where we arrive at on a proper analysis of these particular cases. There having been such people, it necessarily follows that some such time must be allowed. And if one doesn't arrive at that conclusion, one gets to the circumstance of saying, well, let's label everything, and here I paraphrase, I'm afraid, let's label everything that happens as suitable, so that we can recognise the difficulties that confront a city such as Birmingham. And in my respectful submission, that's not a very satisfactory way to proceed. Far better to recognise the duty for what it actually is.
When you say recognise that everything is suitable, what about the prospect of suitable pro temp and suitable for the
Well,
time
no,
being?
I understand all that, my lord, and we have to just track back for a moment because where this gets to be really important as far as individuals are concerned is not so much those who have said, I will leave where I'm living at the moment and I will now take up your offer of some temporary accommodation somewhere rather unpleasant probably, and then I'll hope for the best there and then I'll get moved down the line and so forth. Deal with the person in step one who is confronted with that question effectively and says, well, no, actually, I'd rather stay where I am. I've put up with it so far. It's not reasonable for me to be here. You can't classify it as suitable, or you don't actually need to make that necessary determination at that stage, but please, I want my duty to be fulfilled, and I don't want to have to be confronted by the choice of saying, you must go here to, my Lord Justice Lewis refers to the Travel Lodge, give it some inferior trading name. You must go there, and by the way, if you don't go there, we'll be able to wave you goodbye because our Section 193 duty...
I'm just trying to appreciate from the point of view of the system and of the housing authority what problems would be thrown up if you had written the letter in this case to one of these applicants saying we fully accept that this is not long-term suitable, but we consider that in the circumstances it is for the time being suitable. They would then have a decision which they could challenge. If they didn't like it, they would either have to, as it were, stick or twist. They'd have to challenge that decision, or move into into the system if they weren't happy with it. So, what problems does that give rise to, and what distortions of the system would you be concerned about?
Well, the principal distortion is that which I've just identified, namely that there can be circumstances where it is more satisfactory to recognise a duty is being performed, but it's taking a while, I'm afraid. But meantime, please stay where you are, notwithstanding...
It doesn't, if I say my formulation, it wasn't, of course, mine, but I mean, just the idea that I'm throwing back to you, doesn't it have the advantage that it states more clearly what the actual position is in the local authority's mind? So rather than some amorphous, I'm performing my duty in this broader way, rather just actually calling a spade and saying this is not suitable, but it's the best we can do for the moment.
Well, my lord, the approach that I suggest does have that ability to be direct in terms of the language. The approach which your lordship is suggesting runs into the difficulty I've suggested, and also runs into the difficulty of Section 206 of the Act, which says you can only do this in one of a limited number, 3 ways. That is to say, you have got to secure that suitable accommodation provided by you, the local housing authority. So we may be talking about someone who's not in such accommodation, by securing that he obtains suitable accommodation from some other person. So that contemplates nothing to do with us in terms of the accommodation and something different.
Yes, but why are you not doing it under 1A?
Well, because in your lordship's illustration, we are talking about the homeless at home person. And your lordship is saying to me that in those circumstances, a great deal of difficulty would be cured if Birmingham City Council were to write a letter to the person who is homeless at home, stating we recognise all that, but for the time being, I'm afraid, you have to stay there, and that's our discharge of our duty. And that can't be the position if the circumstance is one whereby that individual or that collection of people is in accommodation which is other than provided by us, because how would we, in that circumstance, be discharging our function under section 193 in one or other of the ways in 206, which are the exclusive ways of discharging that function, if one says, actually, the duty under 1932 enables the duty to be performed in a reasonable way, reasonable time, one avoids that problem completely because you're simply not there. And one can say openly and honestly to an individual who is homeless at home, look, we've made this decision. I'm very sorry. The circumstances in Birmingham are as follows. We're going to try and fulfill our duty as best we can, as quickly as we can. And the situation for the time being is that's where you will be physically. And if we did otherwise, there's nothing else we actually can do. So that's why it's important, my lord, in my respectful submission. But so much is actually cured in the problems which are visible in consequence of this case, or these cases, I should say, if one adopts and takes a position whereby one recognises that no words such as forthwith or anything of that sort were written into section 193, they were elsewhere, and therefore one can deal with this matter, as I would have it, reasonably.
Can I just check one thing you've said 2-3 times? I want to make sure I understand the statutory source of it. You've said that if somebody was offered short-term accommodation, which the authority thought was suitable, because there wasn't longer-term accommodation available which would be suitable, that the refusal of the short-term accommodation itself means that the duty ends.
Yes, my lord. If your lordship
Is
looks
it 5? Sorry, you tell me which subsection it is.
well, it's subsection 5. They cease to be subject to the duty under this section if, and that's, your lordship's going to read the following words, of course, but that enables the position to come to an end because of subsection 3, subject to this duty until it ceases.
But it's the local authority shall cease to be subject if one is they refuse an offer of accommodation. This is an offer of accommodation, short-term accommodation, in any reputable chain of hotels such as the Travel Lodge. B, that offer of accommodation is not an offer of accommodation under Part 6 or a private rented sector offer. Correct, it's not that.
Yes.
And C, the authority notify the applicant that they regard themselves as ceasing to be the subject of the duty under this section.
Yeah.
Could the authority notify the applicant that they are regarding themselves reasonably as ceasing to be subject to the duty when all they've offered is the short-term, not the long-term, suitable accommodation?
Well, they could, my lord, in my respectful submission, because one, that's what the legislation enables to happen, and two, the position is such a position taken by the authority, I would readily accept as an administrative function step taken by the authority might be subject to the supervisory jurisdiction of the administrative court, but nonetheless they could do that if they wish to do so, and the administrative court, I would respectfully suggest, would have a great deal of difficulty in saying no, you couldn't, when that legislation provides for that, and in circumstances when Birmingham would put on the table in front of the court what they put on the table here and elsewhere. These are the conditions which actually obtain in Birmingham, and this is what life is like in Birmingham, and if you want to come and manage our affairs,
No, this is a situation where they say, we'd rather stay with our friends, or we'd rather stay in what we've got. You offer them short-term accommodation at a hotel, and they refuse that, and you say that's the end of the duty.
well, my lord, that's what the...
And you say that's what 1925 means, and that's it. That's what I wanted to notice.
Well, it does provide that. And, I mean, it has to provide that because there has to be a mechanism within this whereby one can't have, so to speak, a perpetual position where the applicant for relief under this legislation is saying no, 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 but it's got to continue. You need to have...
No, I understand that. If you offer them full accommodation, Part 6, or full private sector accommodation, and they say no, I understand that. But this is a very specific point, which you've told me what you submit the answer is, which is where they prefer to stay where they are, but you offer them hotel accommodation for a few nights, and they refuse that hotel accommodation for a few nights, even though it was only ever intended to be a partial discharge of the duty. That, you say, brings about the end of the duty completely under 1935.
And there's interesting reason why that is so. It's because the Travel Lodge, or to use your lordship's expression, some other reputable hotel, the Travel Lodge is taken for the purpose of the exercise as having to be suitable. And therein lies the difficulty, because if one were to say, no, let's operate on a basis whereby there's a reasonable time to fulfill this obligation which has been cast upon the Birmingham City Council, one could perfectly sensibly contemplate a circumstance whereby Birmingham, not being stuck, so to speak, on the horns of a dilemma, were able to say to somebody, you're homeless at home, and we're not going to be able to get you something for some time because Birmingham is Birmingham. And therefore, what we can do is we could put you into the Travel Lodge or some other reputable hotel. And we're not going to regard that as suitable because we don't want to get into a position where people can say you should get shot of this duty. But that's going to be the reasonable way in which we're performing our duty, which is a continuous duty. And then we hope, and probably it is a spades rather than a determination of an actual situation, we hope that there will be a accommodation to suit your needs in due course. And so it's because of the way this has all come to be treated in, I would say, a rather artificial way, touching upon suitability rather than grappling with the question, what is the obligation under 193? Is it a matter of reasonableness? We say obviously yes. And then if it is, a whole load of other issues actually fall away. Now, your lordships could say to me, well, they fall away in favour of the council, don't they? To which I answer, not necessarily, and in any event, we remain subject to the supervisory jurisdiction of the administrative court, but we're able to point to the fact that Lord Justice Scarman in the Bristol case, which we saw yesterday, said that if we are honestly and honourably doing the best we can, we won't be touched by a mandatory order. And no one has said or suggested that we are both dishonest and dishonourable, or one or the other. So, my lords, that's really how I come to deal with Ali. It took slightly longer than I had supposed in starting this aspect of reply, but it is a really important point to grapple with, I suggest, in dealing with this question of the duty which obtains. My lord, can I just pause for a moment just to see whether anybody is going to prompt me about any other matter?
Thank you very much.
I'm much obliged to your lordships. I'm sorry I took a bit longer than I had hoped.
Don't worry. Well, I think we'll just rise for a minute or two. I'll just check whether my lords have anything they want to ask you. Okay. We'll rise for a minute or two just to allow you to, Mr Westgate and Mr Rutledge to get into position. You, if this is the case, to depart. But we will literally only be out for a minute or two, so be brisk.
Yes, we will, my lord. I'm much obliged to your lordship. And I hope your lordships don't think there's any discourtesy that
No, certainly not.
I'm much obliged. Well, he wants you closer, Martin.
Yes, exactly.
He wants closer, either so that he can throw brickbats at you more readily, or otherwise. We've got to get this stuff away from under here. This is all our stuff here. So who is staying out of you two now? You are, you and this. Is that okay?
No, it's not. I'll stick it down.
Yeah, I think that's a good idea.
We're leaving you a little gift, Martin. Bottles of water.
Well, that's extremely kind of you.
Okay, but we do want you to remember that in future cases.
Yes, but I have to say I had forgotten that you weren't going to be furnished with water.
Yes, I know, that's another case, isn't it? Yes. I bet you it's never restored. I don't think we've left anything. That's not our suitcase, is it?
That's mine.
Okay.
There's something
Yeah, especially.
Why don't you see the hands of it, and then also all this stuff is on. Yeah, there was a plastic bag somewhere. You're staying, you're going to make sure we can't
Just
take
for
it.
this one. They're also a bit
So see you a bit later, Annette. Where I expect you to report on swimming. Just be outside, John.
Yeah.
Okay? Good to see you both. Thanks very much.
wishing them all the best.
Yes, Mr Wade.
Yes, my lords, the Imam case is only concerned with relief.
Yes.
The deputy judge was faced with a case of severe delay, where at the time of the hearing, the claimant, in fact, still claimed in an accommodation that the respondent had been unsuitable since June 2015. So that was nearly 5 years before the proceedings were issued, 6 years by the time of judgment, and now 6 years, 9 months. It is, we say, an exceptional period, and far longer than other cases where mandatory relief has been granted. Although we accept that length of time may not in itself be decisive, it's fair to say that delays of this kind tend to be destructive of the right itself. One can easily contemplate a case where disabled children may end up having the whole of their remaining childhood pass before suitable accommodation is provided. Delays of this kind are countenance. On a practical level, even if delay isn't in itself decisive, it's suggestive, at the very least, that there has been some serious failure that needs to be addressed in fulfilling duty. In this case, there was no basis for thinking the breach would be addressed without an order from the court. And against that background, the appellant says this is an extreme case.
Can you speak up a little?
It's an extreme case where the judge erred in principle. And our appeal grounds really group under two headings. I'll simply identify them without trying to particularise them further, because I've seen what happens when that's attempted. So the first is that both principle and authorities point to the burden in a case like this being on the defendant to show compelling and cogent reasons, we say, why an order shouldn't be made. And the judge failed to give effect to that, what we describe as an imperative to uphold the law and to enforce the law, unless there's a good reason not to, and I'll come on to the test for that that comes from the authorities. There are a series of other errors that we say the judge made on the way to that, and I'll get into those when I come to them, rather than try to enumerate them now. So that's, in effect, the wrong in principle point. There's a second point, which is much more discreet.
And the label for the where the judge went wrong in principle, that showed itself in various particular ways, was not recognising the burden on the defendant to show why an order should not be made to comply with the law.
It's partly that. It's partly having regard to relevant matters. Because
okay, that doesn't sound so much like wrong in principle, but sorry, I know. Well, even with your attempt to be very brief, you haven't stopped me asking questions, but I will stop myself.
Thank you. But it's.
That's the wrong.
But I'm now finding myself dragged into making the point. But it's partly failure to recognise the burden, and it's partly irrelevant consideration, particularly resources.
Yes, I see.
And it's also can be characterised as misdirection, because in parts, what the judge appears to do, well, first of all, he misunderstands Ali, and where matters are pitched in Ali. But also, particularly when he comes to talk about the position of other, what he sees of as competing claimants, he mischaracterises the nature of the exercise that the court is being engaged in. And I'll come on to explain that in a little more detail, but the thrust of it is that this isn't a challenge to a discretionary allocative exercise on Wednesbury-type grounds. It's a claim to enforce a direct duty. And also the second heading, as it were, is an error of law point, pure and simple, which is whether the authority can lawfully acquire a property to provide to the claimant in discharge that the discharge its duty, or whether that's precluded because any such property, if acquired, ends up having to be disposed of in accordance with policies under Part 6 and Part 7. And we say that the clear answer is yes, that such a property can be acquired, and for convenience we'll call that the ultra vires point. What I propose to deal with, subject of course taking a different view, is firstly to make some points on the evidence, really just to set the context for the points of principle that we say arise. Secondly, to make again a few points about the legal framework. You've heard a great deal about it over the last best part of 2 days, and so I'm not going to repeat any of that, but there are a few short points I want to make. Then to deal with the principles that we say govern the grant of mandatory orders in this context. Then, I think I'm on the fourth point here, to identify whether the judge fell into error in that respect, so the error in principle point. Although it's fair to say, and then I'll come on and deal with the varies point. And just for the ease of the flow of the argument, I hope, I'm going to deal with the arguments that the judge addressed about fairness to competing claimants after I deal with the varies point, because their arguments are the same type. And then I will come on to deal with disposal, and that also leads me to the point about the applications by both parties to adduce new evidence, on which I don't know if the position has been communicated to the court, but the parties have an agreed position on that. Again, subject to anything.
Which is that one lot can go in if the other ones can, is that it?
Yes, but it's subject to this, that the appellant, of course, accepts that before we get to that, we have to show that the court should interfere with the decision as it was made.
Yes, but you're not going to, well, you may, but you're not likely to get an answer from us. So all this bill will be as it won't be any essay, won't it?
Yes, it will.
Without prejudice or something.
Yes, there are the options really are that we address you on the decision, and then ask to address you again on the new material and remedy if we succeed. The other option is that we just deal with all of this together.
Obviously, have you got an agreed position on that?
Yes, we have.
Which is that we should.
We just get on with it.
Yes.
And deal with it.
Yeah.
I've seen the witness statement of Mrs Imam, the
Yes.
recent witness statement of Mrs Imam, because I said we should consider that at the hearing. And I've seen an application notice for witness statement for somebody else.
Bergen.
Bergen, is it?
Yes.
But I haven't seen a witness statement. I've only seen the application.
There is a witness statement. It ought to be in the page 223 of the supplemental bundle.
The supplementary bundle.
Then I haven't got it.
So I don't think this has tabs, but this is the fifth divider of section 6. It's the last tab.
I just have I see, yes. It starts in my bundle at 223, yes, John Belgin.
Yes.
But I haven't read that.
No, well, it's I doubt that
We won't get to it tonight, I suspect.
today. So if I can deal first of all with the points I wish to highlight on the facts, and those really go to these issues. Firstly, about the nature of the admitted and long-standing breach. Secondly, to the evidence that there was about the claimant's current circumstances. And to demonstrate, we say, that there wasn't in fact any real dispute about it, or any basis for doubting its continued effect. Then to show you a bit about the policies. Principally, the Part 6, I probably don't take you to, but it would be useful to show the Part 7 policies. Address the point whether or not there will be any collision with those policies that the judge accepted. and then also to deal as briefly as I can with the lengthy evidence that was put in by Mr Beasley. And his suggestion there was in effect nothing else that the authority could do, whereas in fact we say that there was a considerable amount that the authority could do. And that in that respect the statement of Mr Beasley is as significant for what it doesn't say as it is for what it does say. So as I've indicated, dealing with the first point, the applicant's been in, or the appellant's been in unsuitable accommodation for what's now 7.5 years, since September 2014, and the breach has been accepted since the 5th of June 2015. And from that point, as is now common ground, as in fact it's been common ground throughout, Croydon's in breach of duty under section 193 to secure suitable accommodation. It admits that's the case, and so nothing in this case turns on Elkundi ground 1. The findings in the judgment, paragraphs 3 and 4, set out the family circumstances and basic details about the property. The claimant occupied the premises with her partner and 3 children, although the children's ages don't appear on the documents at trial. We now know from the further statement that they're aged 11, 15 and 16, so it's a growing family.
At what date are they aged 11, 15?
That's now. So when they went into occupation, they would have been 3, 8 and 9, if my arithmetic is right. That can't, yes, that's... and so the property was accepted in 2014, the claimant having been in bed and breakfast accommodation before then, from February 2014. And that was at the same time she put in an application for a review of its suitability. And the premises were visited by an occupational therapist who identified various issues, including a significant problem she identified, being a lack of a toilet on the same floor as the bathroom. Her report is at the supplementary bundle, tab 14. I would ask you to turn it up.
We haven't got tabs of page numbers.
I'm sorry, in which case it's the it's page 12 of the
Yeah, I got
page
it.
12 of the supplemental bundle.
Right.
That's
Yes, try and just make this plea, as almost hardly a case goes by when I don't have to make it, that it is useful to have tabs, and certainly if they're in the index, it's useful to have bundles which actually have the tabs indicated in the index. But there we are.
yes.
Page numbers will do. Okay.
Yes, I'm grateful.
And can I award a bouquet to the person who prepared the bundles, because they managed to do what so few people do, which is to make the electronic bundle numbering match the proper numbering.
Yes, that's
which makes a great deal of difference.
yes, without having to mentally subtract or add.
Which I've been doing for the last 2
as
days. Every single bundle has a different number attached to it. Keeps you awake, but
There you
no
are.
more can be said for it than that.
I'm Lord Justice Brickbat, and this is Lord Justice Bouquet.
Following the occupational therapist's report, there was a minded to letter was sent, and the appellant solicitors responded to that.
So, what's that mean? Minded who was minded to do what?
I'm sorry.
I'm minded to go to the theatre this evening, but I mean...
I'm using
Yes.
the review process.
Oh, right, okay.
So
there's a request for a review of the suitability, was
Yes.
there? Ah, right. And there was a provisional or minded to letter on the outcome of the review.
That's right.
Ah, right.
In their response to that letter, which is in the supplemental bundle, page 178 to 179, I don't need to ask you to go to them. The solicitors for the appellant included information that because of difficulty accessing the toilet on the ground floor, she'd had accidents in the course of the night because of the slowness of the lift. It's also right to note, and perhaps I ought to ask you to look at this letter, but if you can go to page 178 in the supplemental bundle.
It seems to be under the dates at the top. Yeah.
dated 23rd of April, if you have it.
Yep.
And it's the point is made about the access to the downstairs toilet at point 1. But then the letter also goes on at the over the page to say that it may be that if you're unable to accept the accommodation isn't suitable on a short-term basis, you'll agree that long-term it's not suitable to enable her to be allocated accommodation better suited to her needs at some point in the future. So the response to that letter expressly raised the possibility that's been the subject of debate over the last 2 days. Notwithstanding that, when the letter was dealing with the review came back on the 8th of June, that's at page 183 to 184, the reviewing officer decided to overturn the decision. One sees that at page 184, second paragraph. The decision that 163 Sumner Road is suitable, and then says, in view of the bathroom facilities being on a different level to yours.
I'm sorry, you're going too fast and too soft for my old ears. Which page are we on?
Page 184 now, which is the second page of the review letter, and we can see in the second paragraph that the reviewing officer there overturned the decision on suitability. So there'd been a decision that was suitable, that was reviewed, and the outcome of the review was success for the appellant.
Yep.
And so there are 3 points I make about that. The first one is that in view of the correspondence, the decision that this was unsuitable in an unqualified sense was one that was made with the authorities' eyes open. They had the possibility of suitability pro tem expressly raised in the letter from the solicitors, but didn't take that up. The second point is that, as the members of this court will be aware, suitability decisions are often very contentious and may give rise to applications for reviews and the like. And the you've been shown today the decision of the Court of Appeal in Sakapima approving a jury, which makes clear that in deciding what's suitable, considerations like the availability of other accommodation resources and so on can be taken into account. And so the decision by the authority that this is unsuitable accommodation, or overturning the decision that it's suitable, means that all of those issues, all those pressures on the authority and the like, have all been decided in the appellant's favour.
In that it didn't take up the possibility of suitability pro tem, as you put it.
Yes.
It may be that, given the state of the law, it didn't appreciate that that was a valid position, if indeed it is.
Well, it's...
Your point is that Dayton Pierce Glynn had drawn it to their attention.
Expressly drawn to their attention.
Yes.
I understand
Yes.
that. And it isn't considered, and so one doesn't know what went behind the review decision. But the review decision could be understood just on the basis that because of the particular layout of the property, it was a binary suitable, non-suitable decision.
Well, that is what it says.
It is what it says.
And it's...
But I mean, this is just in passing. It doesn't bear upon your appeal. But in saying that with its eyes open, the local authority said unsuitable, which is exactly what you've shown us, it may be that if there was an option to say, well, it's suitable for now but not for later, it hadn't appreciated it.
Can I come back to that? Because the Always, or the Ali, was some...
Yes, before that, yes.
5 years old by the time this letter was sent. And although it's been subject to some very close analysis in this court, the idea that accommodation could be suitable for a period, if not indefinitely, wasn't at the time one that I'm not really in a position to make this good by any reference, but it isn't one that appears to have been at the time controversial or difficult as a concept. But I'll, if there's anything I can point to on that, I come back to you tomorrow morning. The third point I make, and it comes really to the point that my Lord Justice Jackson's just made, is that the letter refers to the bathroom facility being the reason why the accommodation is unsuitable. But that, we say, doesn't mean that the other issues that have been identified about that property, and I'll come on to really when we come to relief, are irrelevant. You've heard a certain amount today about the process for review and appeals in the county court. That, of course, is only available if a decision is made that the accommodation is unsuitable. And so by making the decision suitable, which of course was welcome and in favour.
No, making the decision is unsuitable is in your favour.
Yes.
You
Because
misspoke.
I'm sorry, yes.
Yes, you must have it the wrong way round.
Yes.
Yeah.
But what it does is mean that she has no forum for saying, yes,
so,
but it's
so
also
what-
unsuitable for
the
others.
local authority can't limit the form of unsuitability by simply mentioning one of a number of matters in a review decision. Is that what you're? Is that what?
Well, it's what it means is that when one comes to consider relief,
Yeah.
you can't say yes. It's only because of
It's
this.
just the bathroom.
Yes.
Well, you've got to look at all the evidence. You've got the disability assessment. I know what you say about the absence of evidence. It's not for the claimant to show. But there's nothing from the claimant saying anything else. You've got the decision letter and you've got the disability report. Was there anything else?
Well, yes. I'm
You're going to come on to
You're going to come back to that later on.
now, if I may. Just before one gets to that, there are numerous letters asking about what's being done. That's dealt with in the judgment at paragraphs 10 to 17. Then the claim was brought on the 3rd of March, and we see that at the claim form at...
Which year, sorry?
sorry, 2020. See that in the claim form at page 139 of the core bundle. Well, I think I have that wrong. It's
133, 132.
yeah, it's
132.
yes. No, sorry, yes, it's 132. Sorry. And I'm sorry, my bundles are in two folders, which is. But yes, so got 1 through 2, and one can see if one goes to the grounds that paragraph 4 at page 139 sets out the only bathroom properties on the ground floor. So it's in effect the substance of the letter. So it's in the claim form, and although we don't have the signed statement of truth in this bundle, it was. I'm told that it was accompanied by the usual statement attesting to the truth of that. So there was evidence there, but there was also the letter in response to the reaction protocol. I'm sorry, there was also the letter dealing with the review, which was in the agreed bundle before.
Yeah, but that's not evidence. That's what the solicitor said. I mean, I'm not.
Well, it is. We would suggest evidence because it was a document in an agreed trial bundle, so is admissible as evidence of the truth of the contents under the practice direction to part 32, which it's not in the bundle, but I'll
Okay.
so
It may have
it's-
changed since my day. Yes.
So there's that. There's the claim form attested by statement of truth, but significantly also, in defence to the claim, the defendant put in the statement from Mr Beasley And he, at paragraph 70, so one has to go for this to...
Sorry,
Supplementary.
I've got rather behind. The PAP letter you say counts as evidence because of some particular practice direction.
Yes, it's a practice direction to part 32.
And what para?
I think it's paragraph 2.9.
Because although it was a long time ago, when I started, the rule was the other way around. Putting an agreed bundle didn't mean you agreed every
Yes, but
sentence.
you agreed the authenticity of the document, but not
Yes,
the
but
But not the contents.
Yes.
But you're saying you agree the contents.
Well,
don't you?
no, you don't agree. It's evidence of it. It's not.
you agree the admissibility, but not the truth. Is that it?
Yes.
I don't know how much to turn on this, but I'm just going to check that while we're
People
here.
are always judicially reviewing pre-action protocol responses, and they're not a decision.
Yes.
They're a
No,
response.
I'm sorry. I'm referring to this as a protocol response.
Yes, you're referring to the actual letter that
it's a
starts the
reviewing
proceedings.
letter,
I mean, I'm not saying it's wrong, but I'm going to write a letter this evening saying you've done all sorts of things to me. Send it out, put it in the agreed bundle, and it's proof of the contents that you've done those things.
Well, then you can
self-serving.
object. You can object to it.
I can object.
Yes.
Is that right? So every time an agreed bundle goes in, you've got to read every sentence and check whether you disagree with anything said. Can't be right.
Yes.
So this is, sorry, practice direction 32. Do you say paragraph 2.9? There isn't a paragraph 2.9.
It's, let me. Yes, I'm sorry that I'm being prompted, but it's paragraph 27.1.
Oh, right.
27.2.
Okay, thank you. Let's have a look.
Yes, so all documents contained in bundles which have been agreed for use at the hearing shall be admissible at that hearing as evidence of their contents unless the court orders otherwise or a party from this objection.
Well, well, well. And do we actually see in real litigation practice people writing saying, I haven't had a chance to read everything in the bundle, but I object to the admissibility of all of it?
Not that I'm aware of.
Or do you likewise
I certainly
see
may
letters
start
saying,
that.
I just want to draw your attention that the documents on pages 46, 522, 646, paragraphs 3, and whatever it is, are not agreed? I mean, is this sorry, it's a rather silly way of putting it. Is this exercise regularly done in litigation practice these days?
It's not what I'm not something I'm aware of in.
No, that you're in silk. You don't have to worry about these things.
But it's and I don't know what the
Well,
practice in.
I've expressed my slight surprise, but it appears to say what it says. So.
Yes.
But I'm slightly concerned because there are decisions, for example, of the Court of Appeal just recently with the Lord Chief Justice saying that the position in judicial review is that if the respondent, the defendant, has put in material by way of witness statements, and there's a conflict about that, then you take the evidence of the witness statement of the respondent, and it's for the for the claimant to, in effect, demonstrate that it's not true. And there'll be a number of ways of doing that. One of them is inconsistent documents from the defendant. The other is to apply for cross-examination. So it's a bit odd to see this used when there are specific cases, and I wonder if somebody should tell the Lord Chief Justice about this.
Yes, it perhaps isn't.
My lord can do that next time he bumps into him in the corridor.
It perhaps isn't inconsistent with the established practice, because this doesn't say that it's anything other than admissible evidence, and so the practice that my lord indicates is one that would apply in a witness statement.
You'd say, well, there's the witness statement of the defendant, and there's the comments in the pre-action protocol
Yes.
letter, but unless they can demonstrate that the witness statement is wrong, that's it.
Well, that would be the usual approach.
In JR, in judicial
review,
review.
and nothing here.
Well, you say it's admissible. I take the point about that. But if it's admissible and uncontradicted, that's the difficulty.
Well, except the impact on the claimant wasn't contradicted. Certainly not by any evidence. In fact, on the contrary, when you go to Mr. Beasley's statement, which is supplemental bundle, it starts at page 19, and the bit I want to show you is page 35. he says, and this is after he's visited the property recently, he says, while the defendants accepted the property is not suitable to meet the claimant's long-term needs because it doesn't provide level access to vast facilities, and this presents the claimant with difficulties at night. So that was the defendant's own evidence, accepting really the thrust of what was being said. There's a similar point, although it doesn't quite go to the same extent, paragraph 72, page 37. I consider the claimant's current accommodation moderately affects her disability, but the impact on her is not severe enough to warrant application on the body. So Mr Beasley appears to have accepted substance, as at the time that he made his statement, of what was being said about the impact on the appellant. And of course, if that impact had been ameliorated in some way, then one would have expected that to have been said in the course of the proceedings, because the claimant's duty can.
I don't think anyone is doubting the fact that this claimant is disabled, that the toilet is downstairs, and if she has to go to the toilet at night, there are going to be problems in getting down in the lift quickly enough to get to the toilet. No one is doubting that. And we're not in a position to know how awful that is night after night. We just haven't lived there and been through it. But that's the extent that it goes to at the moment from what you've said.
Well, it is, but it's also not right to say that it wasn't doubted, because if one goes to the way it was put in the judgment, and this is reflecting what's recorded as a submission, so if I can ask you to go to the section where the judge sets out his reasons for the refusing relief, it's paragraph 81. He says at page 67, so it's paragraph 81 to one over the page. And the point there was made here, it's about 5 lines down, the sentence beginning, as Mr Rutledge correctly submitted. The court doesn't know what the current impact is of the problem regarding the location of the bathroom property, and I accept that the evidence goes no further than what I've just shown you. But it goes on to say, or whether the claimant has found any practical ways to manage such difficulties as she encounters. So the point was being put, well, this might have been the case in 2015, but it's not the case now. Or it may not be the case now, or at least you haven't demonstrated it's the case now. And that doesn't tally with what I've just shown. And to go further than that, to say that, well, if it had been the case that she found practical ways to manage such difficulties, then she would have had to say so in the course of the proceeding. And the court can't proceed on the basis that on the basis of no material, that there's something that's happened that she hasn't told the court about.
Well, it is odd that a claimant doesn't put in a witness statement in support of her claim, not least because there is the obligation on the claimant to put forward all the relevant facts. It's very, very unusual to have litigation, particularly of this nature, particularly when it's intimate circumstances that only the claimant can know, that she hasn't put in witness statements. It's very, very unusual.
Well, one sees the explanation that was given at trial at 81.1. It follows the passage I've just shown you. And on the face of it, this was a case where evidence was given in the claim form, attested by the usual statement of truth, and very often one simply has the claim form without necessarily having to have a statement in support if everything is set out.
There was a statement, wasn't it? It was a very rudimentary one at page 199 of the supplement.
Yes, that was in response to a point that was made by Mr Beasley. Of course, there'd be no point in responding to Mr Beasley on this issue because he'd admitted it. On the issue of
so you were building your case on their evidence, essentially, if one treats evidence as witness statements.
Well, no, because there was already evidence, there was material in from the claimant. When Mr Beasley put in his statement, he said, yes, I admit it's causing difficulties. And so when a further statement went in that addressed a particular issue that Mr Beasley raised about furniture and about bidding on Croydon choice, she addressed what then appeared to be contentious issues. But of course, at that point, impact on her didn't appear to be a contentious issue because Mr Beasley was admitting it.
But the judge didn't say there was no impact. I mean, no one's denying that there is no upstairs toilet, and if the woman wakes at night, given the lift, there are problems. That's all the court knows, and it wasn't doubting that. It's simply saying quite how much that has had an effect on her day-to-day well-being, quite how much it's worn her down in the last 5 years, we don't know, because there's nothing wrong with her. And we don't know, and therefore we can't assume, that there's been ways found around it. We just don't know what's happened in the last 5 years. That's all the judge is saying. Is he saying more?
Well, he's going rather further than because he does say saying that we don't know whether she's found practical ways to manage. He's suggesting, well, it might have ameliorated, and we don't.
It might not. That's all he's saying. It might not.
Well, but given the state of the evidence he had, it's not open to him to speculate that might not, or it might have. But that's the evidence.
It doesn't go either. All it says is we don't know, and therefore we don't know.
Well, I'm not going to
Anyway.
press what exactly you said there. I'll come back to it, although I think you've got the thrust of what I'm going to say. So I'll try.
I've just been looking at the original JR claim, which you took us to a moment ago.
Yes.
And simply because it weaves in with something that you were saying earlier. The way in which the claim was pleaded, and I'm looking at page 142 in the supplementary bundle, that, again, this may simply be an observation, paragraphs 19 and 20, the way in which you pleaded your case, put quite clearly the distinction between long and short term in those two paragraphs.
Yes. Yes.
Nothing turns it was simply that it's a feature of this case, unlike the other one, that there was a lively attempt on your side, as it were, to maintain the distinction between something that might be all right in the short term but was not all right in the long term.
Well, yes, it was, in one sense, it was unnecessary to
Yes, but you didn't know
strike
you were going to get the result you did.
It was never an issue in this case because the breach was admitted.
Yes, I know, it may shine more light on the other case than on yours, but nevertheless, just in looking through it, I see that somebody did plead that.
Yes, and of course, by that stage, obviously that's sometime after the suitability letter, but it's drafted on the basis that that's well established. But that's the.
Sorry, we've been. Are you about to move to a new point?
I was about to go to Mr Beasley and his evidence about the allocation policies and what he.
Well, that's quite a major exercise, I suspect, isn't it?
It is. I'm.
Well,
it is, yes.
Well, if you're keen to sit till 4:30, we won't say no. But it
That
just
clock is wrong.
the clock is wrong, and B, I don't get the impression that we're going to be sort of, we're going to be pressing up against.
I don't think we are. I've not got through a huge amount, but I can. We will.
Well, let's see how we go tomorrow. Anyway, the really question is: do we rise now? And the answer is yes.
Yes, I'd have to stop halfway through the.
Okay.